Welcome, everyone. Thank you for joining Mayor Brown's Cybersecurity and Technology Transactions webinar. Our program today will focus on security and privacy in the cloud. I need to cover a couple of administrative matters and then we'll get started. We schedule periodic programs on technology transactions topics, so if interested, look out for future invitations and feel free to spread the words to others who might be interested. You can also find many past programs on our Technology Transactions webpage. That's www.mayorbrown.com/experience-technology/transactions. You'll also find our website on the materials. For the lawyers participating on the call today and applying for CLE credit, during the presentation, you'll be provided an alphanumeric code. You'll need to record the code on the virtual sign-in sheet that you received by email with the connection details, and you'll find the directions for returning the virtual sign-in sheet on that sheet itself. We will read the code in the middle of the presentation and then again at the end of the presentation. We hope to allow time at the end of the presentation for questions. To submit a question electronically, please use the Q&A panel in WebEx. If we don't get to your question during the webinar, we'll make every effort to follow up with you after the webinar. As Jackie mentioned, this webinar is being recorded as we normally do with these programs. In a day or so, we'll be sending them an email with a link to the presentation, and the recording will also be posted on our website. Turning to our panelists today, my name is Linda Rhodes, and I'm delighted to participate with my partners Brad Peterson and Joe Pennell on today's topic. I'm a partner in the Washington, D.C. office of Mayor Brown's Technology Transactions practice. I focus my practice on complex technology transactions, including business process and technology sourcing and digital services. And I have experience in handling the data security and privacy issues in the context of these complex transactions. I'm pleased to introduce my fellow panelists. First, Brad Peterson is a partner in our Chicago office and the leader of our technology transactions practice. Brad helps global companies work more effectively with their technology suppliers, and he's one of the most experienced and highly ranked outsourcing lawyers. Brad's represented clients in increasing numbers of contracts with digital service providers, including the cybersecurity and privacy issues related to those scopes. Joe's also a partner in our Chicago office of the Technology Transactions practice. He focuses his practice on information technology and managed services transactions. He's also the co-chair of ABA's section of Science and Technology Law's Cloud Computing Committee. On slide 3, we provide more information about the breadth, experience, and recognition of our Technology Transactions practice. We welcome you to peruse that at your convenience. One more brief introductory point before we get started. The participants on this webinar represent customers, suppliers, and other industry players. We'll primarily be walking through the points from the customer's perspective. However, we believe the discussion will be providing insights for all relevant parties. So to kick us off on slide 4, businesses are increasingly turning to cloud solutions, and they're accumulating data in the cloud at a staggering pace. This is due in large part to the significant advantages that cloud solutions have over traditional outsourcing. For example, they offer little or require little, if any, upfront investment by the customer, and they allow customers to quickly ramp up and down their resource usage. However, cloud solutions also present challenges for complying with data privacy and cybersecurity regulations. To successfully use cloud solutions, and in particular to ensure that your usage remains compliant with regulations, the customer needs to fully evaluate, first, the nature of the data that will be placed on the cloud, second, the associated data privacy and cybersecurity laws that are applicable to that data, and third, the structure and location of the cloud solution. Next slide. I'll start with just a few fundamental points to set the stage for our discussion today. A cloud solution generally refers to a type of service under which the provider utilizes shared computing resources to provide services over the internet for multiple customers. Providers typically maintain the freedom to move data to maximize resource usage across the customer base and also to lower cost. However, because of the multi-tenant nature of cloud solutions, providers have little ability to customize a public cloud solution for any particular customer. So initially, this limited customization presented risks for using cloud solutions, but with time, providers are becoming more sophisticated in understanding the need to develop cloud solutions designed to meet regulatory requirements. As an example, certain large cloud providers offer additional audit services as an add-on to their core service offering. In addition, many have separate environments specifically designed for HIPAA and financial services compliance. And if the data that is going into the cloud is subject to those kinds of requirements, you can work with your provider to provide the right solution. However, of course, the customer always needs to do its own diligence to confirm that even these specialized environments meet their particular needs. Additionally, contracting practices have become more mature. For example, whereas a cloud provider may not be able to customize its environment to meet any particular customer needs, as we'll discuss further today, the provider will likely have certain industries, agree to certain industry standards or agree that certain security protocols, while they may change over time, are not going to become less stringent than those in place in the contract date. So there is some flexibility to contract for these solutions in a way that meets your needs. So these types of developments are enabling the expanded use of cloud computing by customers. Brad, I'm going to turn to you next.
Thank you, Linda. On slide 5, Linda's talked about the benefits of the cloud. Unfortunately, the benefits of cloud have to be balanced against the risk of a data breach. And to set the stage for this, the impacts of a data breach might include the expense to investigate and respond to a data breach, which may be substantial in terms of hiring consultants and advisors and so forth. But it goes on. There's damage to the brand and reputation because of the requirements to notify, and thus you may lose sales as customers say, hey, this company is not a reliable place to have my data. That leads to disruption to management, to public relations, to marketing and operations as the entire company scrambles to address the results of the breach. Then the regulators step in to help with regulatory fines, sanctions, or mandates. And the biggest news today in the data privacy area is that the European General Data Protection Regulation, the GDPR, imposes a fine up to 4% of global turnover for breaches. This, of course, will also anger shareholders who may do shareholder derivative suits against directors and officers for having failed to adequately secure the assets of the company, and consumers who may sue because their data has been breached or abused, and there may even be suits from credit card companies and others who are harmed because of the data breach. And then there may be collateral damages to a variety of other companies, including the credit card companies. So there's tremendous possibility for adverse impact. Let's go to slide 7 and talk about how those risks tie to cloud deals. A familiar phrase is that your security is as good as your weakest vendor's security. The attackers will attack your weakest point. When you expand your threat surface by putting your data into a cloud, that's a logical place for attackers to go. And even trusted contractors, trusted cloud providers might subcontract vital roles to subcontractors who you might not trust. And there may be, watch out, for example, in cloud contracts for restrictions on first layer subcontracting, but not the subcontractors or the subcontractors. This is a particular problem in cloud computing because the cloud computing deals are often quite small. And as a result, they may have liability caps that are also small. Imagine that the company faces, its estimate, a $10 million possible loss from a data breach. It puts the data on a cloud where the cloud provider has instead of a $10 million revenue stream, it has, say, a $10,000 revenue stream or $100,000 revenue stream, and thus its liability is capped at $100,000. The provider, of course, will do good and logical things to avoid a breach, but it would spend as if it's a $100,000 problem. The company, of course, sees this as a $10 million problem. And all of this has led to genuine failures. We list here on slide 7 some of the examples that we've all read about in the media of companies that have had problems as a result of third-party breaches. For our purpose, and on slide 8, we will today focus on the laws and regulations on privacy and data security, not these other collateral damages. This by itself is a complex area. In the United States alone, we have a set of federal laws which are generally what we call sectoral. We've got laws for the financial industry like Gramm-Leach-Bliley. We've got healthcare industry laws like HIPAA. We've got educational laws like FERPA. In addition, we have various regulators have taken as part of their mission to regulate data privacy, the FTC, the SEC, and some others. Then, most of the individual states have published their own individual laws protecting data privacy. And in many cases, an individual state will have multiple laws on data privacy. So, for example, our state of Illinois not only has a law which protects against breach for financial data, but also has a sophisticated biometrics data privacy law, which is a separate law. In Europe, there are a tremendous number of currently state-by-state privacy laws, but those are being consolidated into a general data privacy regulation. Companies today evaluating cloud solutions must consider both the current and the future European laws. In the rest of the world, the laws are varied and in some cases more strict than either of those laws. For this purpose, a couple of things worth pointing out. First, most of these laws apply to the data owner, the company, but the increasing trend is for regulators and to say, no, this law needs to apply to the provider also. So there may be protection for the company that the provider is at risk, and for any company acting as a provider, liability is being heightened. Second point, most of these laws look to the phrases like reasonable and appropriate. They've gone back and forth between should we try to legislate specific ideas and then finding that those ideas are washed away by the next wave of cyber attacks and technology, or should we set forth a general standard? And for the most part, we're at a general standard that is difficult to interpret. With that, let me turn it over to Joe to speak about some of those laws.
Thanks, Brad. So, as many of you know, and Brad just mentioned, the current EU Data Privacy Directive will be replaced in May 2018 with the General Data Protection Regulation, commonly referred to as GDPR. This regulation is extensive and complicated, and failure to comply can result in heavy penalties, like Brad mentioned, up to 4% of your company's worldwide turnover, or 20 million euros, whichever is greater in some cases. So GDPR is a massive topic, and some of our colleagues will be providing a webinar fully dedicated to GDPR on December 6th, but I'll walk through a few key provisions that are relevant to your cloud contracting efforts. First, who does GDPR apply to? It's not just businesses that are established in the European Union. If your organization is outside of the EU and processes personal data in relation to the offer of goods or services to individuals within the EU, or if your company is monitoring individuals within the EU, you'll have to comply with the GDPR. Under the GDPR, a cloud provider is a data processor or perhaps even a co-controller of data. There are many changes resulting from GDPR that will impact cloud computing, including more sophisticated requirements between controllers and processors that need to be covered in your cloud contracts. These are some examples of topics that a data controller will need to consider when using cloud computing services. So first, privacy by design. A customer buying cloud services is likely the data controller. As the data controller, you will need to satisfy requirements regarding privacy by design. And data controllers will need to determine how their cloud providers have complied with privacy by design requirements. Next, record keeping. Data controllers and processors have requirements to keep certain records regarding compliance with GDPR. Privacy impact assessments. Data controllers are required to perform privacy impact assessments in certain cases. These may extend to cloud computing services. Customers and cloud providers will need to consider who's in the best position to perform one of these assessments. Cloud providers, particularly your SaaS providers, are fully in control of their architecture and how it uses data, and you as the customer might not be in the best position to do the assessment on your own without assistance from those providers. Enhanced data subject rights must be addressed, so transparency, right to be forgotten, rights to object to data processing, etc. All of these concepts need to be covered in your agreement with a cloud provider so that you as the data controller are in a position to comply with GDPR. Breach notification requirements. Organizations will now have to notify the relevant European Data Protection Authority of a breach without undue delay and where feasible within 72 hours. Notifications must also be made to the individuals affected without undue delay where there is a high risk to the individuals concerned. Finally, profiling is an area that will require special consideration under GDPR. Many cloud providers perform data analytics in the background of their cloud services. Customers will need to understand whether any of these functions may qualify as profiling, and if so, customers will need to consider how to comply with GDPR in that event. So, moving on to the United States in the next slide, this slide 10 is just a partial list of some of the laws and regulations that require data owners, including customers and cloud contracts, to take reasonable measures to protect personal data. This includes requirements to take reasonable measures in selecting and monitoring any third party who will have access to that data. So moving down some of the items on this list, Graham-Leach-Bliley contains extensive guidance about financial institutions' selection and monitoring of third parties who process non-public personal information, including cloud providers. HIPAA has privacy and security rules that flow down to third-party providers. If your cloud provider is handling PHI, that cloud provider is going to be a business associate under HIPAA and will need to execute a business associate agreement with your client. As I think Brad might have mentioned, the SEC's enforcement arm recently put out a risk alert in August 2017 with guidance on cybersecurity. And then you have other federal agencies like the FCC, DOJ, and FDA who have also put out guidance on cybersecurity compliance. You also have industry groups like the NAIC and the Auto ISAC that have similarly provided cybersecurity guidance at an industry level. Among state laws and regulations, the Massachusetts regulations contain some very specific security guidance. These regulations are short and well worth reading. Unlike many other laws and regulations that apply to a data owner or controller, these regulations apply directly to owners and processors of personal information, including cloud providers. Customers will want to include certain provisions in their contracts to comply with those Massachusetts regs, and cloud providers should examine them to determine if they're in compliance with those regulations. 48 states now have data breach laws, and the only remaining holdouts are Alabama and South Dakota currently. So, whether or not all of these different laws and regulations directly apply to your business, the laws and regulations that articulate security standards are examples of what is considered reasonable measures given that type of regulated data or similarly sensitive data. Next slide, the FTC. 1/3 of the FTC's enforcement actions are not based on an actual data breach, but rather on an increased risk of security or a misrepresentation about the type of security that a company follows. The FTC for many years brought enforcement actions regarding inaccuracies in companies' privacy statements, but now they bring cases where they believe there is inferior security and/or a misrepresentation about the level of security being used. The FTC's consent decrees with their enforcement targets generally have a common set of requirements, and one of them is that the company develop reasonable steps to select secure vendors. In fact, and Brad mentioned this not in the specific FTC context, but there are several cases where a third-party service provider caused a security problem that resulted in an FTC enforcement action against a customer. Your cloud providers are third-party service providers, and you must apply the same standards and controls that you would apply when contracting with or monitoring any other third-party provider to your business. With that, I'll turn it over to Linda to discuss the New York DFS regulations on slide 12.
In another recent development, the New York Department of Financial Services issued final regulations which were effective March 1st of this year. Those regulations mandate cybersecurity standards for many financial institutions which are operating in New York. The definition of covered entity under the new regulation is broad and includes not only banks, insurance companies, and insurance professionals. The regulations are comprehensive. They address everything from access controls to encryption to data disposal and employee training. What's important to understand here is that this new regulation includes requirements that have to be passed through to the covered entity's third-party service providers, or in other words, your cloud provider. The third-party service provider requirements take effect in March of 2019, and they obligate the covered financial institution to develop and then pass through to their third-party service providers written minimum security policies which are designed to ensure the security of systems or data in the control of or accessible by those third-party service providers. Therefore, what that means is financial institutions that fall within the scope of the new regulations will need to review existing third-party contracts to determine if they're compliant or if they're going to need to be amended. And as a footnote, I think there's an important lesson here that when you're contracting for cloud solutions and other services, you need to think about addressing in the contract the need for the solution to be able to change during the term of the contract for changes that occur in legal requirements. On the next slide, I'm going to talk about third-party access by means of legal process and blocking statutes and the concerns around these areas, i.e. the third-party access to cloud data and blocking statutes, are actually driving the structure of cloud solutions. So what does that mean? As background, federal agencies have a variety of tools they can use to seek electronically stored data, and that includes warrants, subpoenas, or court orders. And those can be used to compel not only the customer, but also the service provider to facilitate access to electronically stored data. However, when you talk about the cloud environment where you have U.S. data that may be stored overseas, this raises novel questions for the legal community. A recent litigation suggests that the U.S. government's ability to access U.S. data that's stored outside of the U.S. is in a state of flux. For example, there was a recent Second Circuit Court of Appeals case that held a U.S. enforcement agency could not use the Stored Communications Act to obtain a warrant issued on a U.S. service provider for email content stored in Ireland, whereas a Third Circuit District Court held to the contrary. On the other hand, data that's stored in the U.S. is subject to the jurisdiction of U.S. authorities, regardless of where the origin of that data is. So what does this mean for cloud computing? Multinational customers are often using several cloud instances or multiple providers around the world to address these concerns. So as an example, a multinational company may both have a U.S. cloud instance and an EU cloud instance, and the EU cloud instance would hold the EU data to protect the EU data from access by U.S. governmental authorities. A couple of footnotes worth mentioning. In terms of access by private litigants, the plaintiff and defendant in an action, multiple courts have held that the provisions of the Stored Communications Act permitting disclosure through a service provider do not apply to private litigants. Therefore, a party to litigation will not likely be able to seek electronic data from the service provider. On the other hand, moving data to the cloud is not likely going to alter the customer's obligations to produce its own documents in response to a subpoena or document request made either by private litigants or U.S. government entities. Secondly, on the topic of blocking statutes, location of data issues are further complicated by many countries that have actually passed blocking statutes, which means they limit or prohibit exporting certain information outside of that country that has enacted that blocking statute. The most prominent examples are China and Russia. So again, when you're talking about your cloud contract, customers are often using cloud instances or local providers in, for example, China, to deal with these kinds of blocking statutes. With that, I'll turn it back to Brad.
Thank you, Linda. So the question now is, how do you address the privacy and data security risks of the cloud while capturing the value? And as Joe has mentioned, the regulators and we believe most of the rest of the sourcing community have concluded that the keys to success are to look at it in selection, contracting, and governance. So I'd like to start on slide 16 with the first steps for the selection process. These are steps to take before moving to a specific project and without the time pressure of a deal. And the goal is to make sure that that you are ready for the selection process. Step one, look for the documents that will help you understand the context for privacy and data security within your company. A first one, and probably the Rosetta Stone of the collection, is the Written Information Security Plan. According to law, every company should have a Written Information Security Plan. And if you don't have one, advocate for one. That is the plan for comprehensively how do you approach information security across your enterprise. Second, you should have a data breach response plan. That's the plan for what do you do in the first 24, 48, and 72 hours when a data breach hits. The Written Information Security Plan will be a guideline for the sorts of contractual provisions and steps and mitigations you need. The Data Breach Response Plan will inform what support you need from a provider in case of a data breach. Then, review the cyber goals and objectives set by your board. Make sure you're aligned with those. Identify the subject matter experts and stakeholders so you know who to talk to when you're in the midst of a cloud contract and you have a data security question. So you have these people on speed dial. Then, to the extent that they aren't already described in the WISP, identify the relevant laws, the policies, the standards, whatever else you might need to comply with so that you know the compliance obligations you walk into cloud deals generally with. Those might be embedded in a cloud contracting policy at some companies. And then finally, as part of selection, you'll need selection tools. And the one that's most common is a data security questionnaire, which asks a provider what data security they have in place already, and will be a great way for you to start on your efforts. As we go to slide 17, which is called Key Steps in Selection of Providers, now you've gotten to, you're in a specific sourcing opportunity. You know what you want to leverage the cloud for. You may have a cloud strategy. You may just be looking at an opportunity to save some money. These are what we would recommend as the key steps. First, identify what kind of data will be accessed or stored by that cloud provider. Second, categorize that data by risk level. And you probably have a risk level matrix which is set forth in your data breach, in your Written Information Security Program or in your cloud contracting policy. Then, obtain copies of the bidder's security documents. They'll often be on the Trust Center or something of that sort on the bidder's website, so you can often find that documentation without even asking for it. But it's often valuable to ask for documentation. Send preliminary questionnaires regarding security, and in those preliminary questionnaires, ask for additional information, perhaps a SOC 2 report under SSAE 18, or perhaps it's an ISO 27001 certification, something of that sort. If you're still insecure, commission some sort of security reviews and audits in advance, and then review all the data that you've gotten back, in addition to all of the information that you collected in that preliminary first step stage, and remove the suppliers with inadequate security capabilities. Your goal is to get to a panel of suppliers or a collection of bidders that you can truly trust. And then finally, we'd recommend that having all that in hand, you estimate the cost of the governance stage so that when people are thinking about how do I contract for this? What's my business case? They have a number to fund the contracting and governance stages. With that, let me turn it over to Joe regarding contracting.
Thanks, Brad. So now we'll move from the selection process that Brad was just describing into some of the challenges of contracting with cloud vendors. So slide 19, contracting preparation. First, there are going to be some limitations in the cloud solution from a business and technical perspective that may prevent you from getting all of the contract terms that you might ordinarily hope for in your technology contracts. For example, when you buy a public cloud solution, you're getting the latest in technology at potentially much lower cost than conventional IT solutions. The trade-off is that you may not be able to dictate security requirements that don't fit the provider's architecture, like physical separation of your data from other customers' data. Second, you're going to need to assess the privacy and security risks of the cloud provider's solution and identify non-contractual ways to mitigate that risk. The easiest approach may be to keep the most sensitive personal data of your organization out of the cloud altogether. Third, assess the risk of locations used by the supplier and find ways to mitigate that risk. As Linda mentioned earlier, many sophisticated providers offer geographically specific clouds, for example, in an EU jurisdiction like Ireland, to help eliminate your compliance risk from cross-border data transfers. On the other hand, that sounds great in theory, but customers need to understand whether their data actually stays in the EU cloud instance, or is data processing still going to occur outside of the EU via remote access from places like India or otherwise. As many of you know, remote access constitutes processing for purposes of EU law. Lastly, identify areas where the provider may use your data, and if you want to try to prevent that use via contract. So cloud providers will frequently offer an innocuous-sounding clause about using your data to, quote, improve our services, or using your data in aggregated or anonymized form. And that sounds okay in theory, but the big data analytics that a cloud provider could be running on your data may disclose valuable information that otherwise might be secret, such as the characteristics of your high-margin customers or maybe your future business plans. We recommend thinking about these issues in the context of your data before you begin contracting so that you don't inadvertently grant valuable rights in your data without even realizing you're doing so. Next, slide number 20, contracting approach. Our experience is that customers don't need to settle for cloud standard terms from the provider based on what their consumer-oriented contracts say. Enterprise customers can and do obtain the protections they expect for critical data and critical services. Ideally, you'll start from your own form agreement if you have the leverage to do so. One cautionary note here is that using a traditional outsourced services form is less likely to succeed than using a more abbreviated cloud-friendly form agreement. A lot of times it's not a given that you're starting from your form versus the provider's form, and you'll hurt your credibility in pushing your form and in negotiations if you're proposing some type of 80-page professional services form that's full of personnel provisions that just don't apply to a cloud solution or otherwise don't make sense. If you're unable to start from your own form with some of the bigger providers, you'll need to instead focus on negotiating the negotiable elements of those providers' form agreements. With the leading providers of these services, if you end up on their paper, it's frequently more efficient to identify an issue with their agreement rather than trying to add in your company's standard provision that addresses that issue. Usually when you identify, a particular issue you may have, the providers can respond with standard clauses that they've already developed and had approved higher up in their legal department, instead of laboring over your language that will ultimately be rejected in favor of their standard clause. You're not likely the first customer to raise a fundamental concern with an industry-specific data security issue, and the bigger providers may have a workable solution for you that they can pull off the shelf. Linda talked about this a little bit earlier. Finally, prepare some type of risk memo that identifies the risk of accepting the provider's terms. This should inform your client's decisions of whether or not to go through with the cloud solution and helps you clearly identify the risks that you can't mitigate solely through contract terms and how you can mitigate those risks operationally or procedurally. So, for example, the provider may only give you 60 days notice of changes to their services, and those changes could conceivably put you out of compliance with applicable laws, whether it's data privacy and security or otherwise. If you're not able to negotiate a prior approval right or a longer notice period for those changes, some clients may elect to mitigate the risk by standing up a parallel cloud solution with a different cloud vendor. You can maintain that parallel platform as a hot backup to quickly transfer your data and operations to stay in compliance if that ever becomes necessary. So these are just examples of the types of things we see our clients doing when they can't get quite the contract terms they hope, and they come up with other creative operational solutions that otherwise, nonetheless address their risk. With that, I'll hand it over to Linda to go through a cloud contracting checklist.
Thank you, Joe. So the next several slides include checklists of data privacy and security provisions to be addressed in a cloud contract. I'm not going to go through these, one by one. You will receive the presentation and, of course, are welcome to use this as you like. And many of these items we've already touched on during the presentation thus far. However, there are a few provisions that I would like to highlight. For example, many privacy laws and regulations require that the customer maintain the ability to monitor the performance of its third-party providers, i.e. cloud providers, by conducting audits. However, in many cases, the cloud provider will not or may not be able to offer broad audit rights that you would get in a on-premises type solution. For example, few large providers will allow you to come in and access their data centers. This is either for policy reasons or risk reasons. Again, keeping in mind that a cloud solution is based upon this one-to-many model. In those cases, our recommendation is that the customer asks the provider what types of third-party audits or certifications of their facilities they routinely obtain, such as multi-tenant SOC 1 or SOC 2 Type 2 reports or ISO 2700 series certifications. Again, whether or not those controls and industry standards are sufficient to meet a customer needs depends upon what the nature of the data is being placed in the cloud and what the data privacy and cybersecurity laws that are applicable to that data. So once again, diligence is the key. Do you need a SOC 1 report or SOC 1 audit of the internal controls over financial reporting? It may depend upon the services you are obtaining. For example, are you seeking finance and accounting services? Do you need a SOC 2 audit, which covers controls relevant to security, availability, processing, integrity, confidentiality, and privacy? Most large providers will do these types of controls audits, and it's possible through your conversations with the provider that they either already offer those up to you or you're able to get them to commit to that in the contract. Similarly, it's not necessarily sufficient to just say you're going to require ISO certification. Your security team should review the statement of applicability, and that identifies the controls that are in place that are being certified to. For example, providers can opt out of certain provisions that are part of the ISO standards. For example, many providers will opt out of the obligation to perform background checks, and you need to assess from your company's perspective whether that's accessible to you or not. Once you determine what the provider actually does, then you can look to your contract to see how to address those obligations. For example, including a commitment by the provider to regularly conduct those audits and report audit findings to the customer, requirements for the provider to implement the controls, and then maintain the controls and certifications during the contract term. So this is an area where there may be some flexibility in negotiating the contract terms or maybe seeking additional services that the provider may offer as add-ons to their core solutions. Also, in many cases, regulators may require the right to audit the customer's regulatory compliance Few, if any, cloud providers will allow that broad access by regulators. But as I mentioned earlier, there may be add-on professional services that you can get from your cloud provider where they will work with you in working through the regulatory issues with your regulators. Similarly, customers may want to ensure that the cloud contract has appropriate physical and operational security measures. So again, depending upon the nature of your data, you may want to require penetration testing or vulnerability scans of your scans, or you may want to have longer log retention periods to ensure there's sufficient time should there be a data breach for you to do your investigations. You know, in some cases, these are rights you can obtain as additional services through your service provider. And then on slide 22, just a brief point on subcontracting. Brad touched on this earlier. You know, certain data privacy laws have actual requirements that the customer maintain the right to approve subcontractors and pass through security obligations to those subcontractors. You have to think about the fact that those subcontractors may have their own subcontractors and down the line. So when you build approval rights into your contract, you want to make sure they apply to subcontractors at all tiers. Skipping over to slide 24, I'll touch again on data breach notification. You've heard Joe talk about that some in his GDPR and state breach notification law requirements. But again, it comes back to the fundamental question of understanding the nature of your data and what laws applies. So you're going to be dependent in a cloud environment on the cloud provider to notify you so that you can then meet your obligations to notify your customers or comply with your regulatory obligations. And you may be subject to multiple laws in terms of data breach notification requirements. So you're going to want to look to your, to make sure that your contract ensures that you comply with the most stringent of those requirements. You know, for example, the GDPR, as Joe mentioned, having the very short, 72-hour notification requirement, and Georgia data breach law, which actually has a 24-hour notification requirement. So you want to make sure you adhere, again, to the most stringent. Additionally, the definition of what constitutes personal data is being broadened under many data privacy laws. For example, in California and other states, personal data includes an email address and password. So when you look at your cloud contract, you have to make sure that the definition of personal data or customer data is broad enough so that you're getting the notice you need in order for you to meet your compliance obligations. With that, I will turn it back to Brad. Brad, you may be on mute.
Thank you. The third phase, after you've selected a set of reliable cloud providers that you can trust, that you've come to good, solid contract terms with several of them, the third phase is governance, and that includes monitoring, demanding correction of problems, and verification of corrections. The contract terms that we've talked about are valuable as tools. They don't solve the problem on their own. They have to be used in governance to be effective. So let's talk about some of the ways that we see our clients following up in governance, which appear on slide 26. The first step is to have a security team or a team that expressly takes responsibility for the security of the cloud platform. Someone at the company has it as part of their key job responsibility to monitor, to follow up, and to verify corrections. And one of the things that they would first take on is the implementation of the risk mitigations that were identified during contracting. And Joe mentioned that there's a value in putting together a risk memo, possibly even a privileged and confidential risk memo, that would indicate some of the open problems not mitigated during contracting. So those should be top of the list for that data security team. Second, I talked earlier about sending a data security risk questionnaire. And the benefit of the questionnaire is that it asks about the security practices that the providers were promising when they were offering the service, but we want to make sure that that provider continues to be reliable as the threats change and the use of the cloud changes. So having follow-on questionnaires that you may send on a regular basis to make sure that the provider continues to be offering the same data security protections and same privacy protections, and obtaining the certifications that were promised in the contract and so forth, and then doing ongoing monitoring of those will help to make sure that you're actually getting what you were promised if you're the company. Fourth idea, maintain that data map. We talked earlier about the importance of having a data map, not a literal map, but a way to find out where a company's data is within the company. And a key is to be able to show where the data has been extended into the cloud. Often when people in the big data area are working on creating new databases, for example, they might take data out of primary databases, the accounts payable database, the accounts receivable database, the various systems of record, and move them to secondary systems. And if it's an end-to-end digital transformation with the intent to serve customers, you might have an online transaction database, which is a secondary database, cloud-based, permitting rapid access by customers to data about the products and services being provided by customers. And you might have other online databases for data warehouses or online analytical databases for use by the company. That means that data is flowing often out of the highly protected systems of record into the cloud. Knowing where that data is allows you to manage not only the flow of data into potentially insecure spaces, but also the application of contract terms. Fifth idea, security audits. Security audits are expensive, and they will obviously not win you any friends at the cloud provider, but the benefit of the security audits is that you get real information, either from the reports that the cloud provider is providing from its auditors or the reports provided by your auditors about the security situation at each cloud provider. They are well worth investing in, and it's well worth having a program where that investment is made on a regular basis. Then a process to review those audit reports and to follow up on exceptions and identified vulnerabilities. Governance is not just monitoring, it's also following up. And that also includes, as a side point, one that we've seen in a practical problem that we see for many of our clients and friends is the need for rigorous policing of access rights and to shut off access rights when a person has left the organization. So with those, you've got follow-up and governance. Let's move to slide 27 just for a few concluding remarks. In conclusion, first, privacy and data security breaches can have a high impact on companies. These are board-level issues for a reason. Second, there is a complex legal and regulatory framework, and that framework depends on your industry, where you do business, what data you have, and other factors. It's worth speaking with specialized counsel who understand the specialized data and data security and privacy framework for your business. Third, cloud contracts might involve particularly high risks. There's a spectrum of cloud contracts. Some of them are with highly secure providers and limited access to sensitive data. Those may be low risk, but there are also certainly opportunities to have high-risk cloud contracts, and the profusion of cloud vendors and the novelty of the technology and the fact that it's inherently accessible over the internet presents a high-risk profile for some cloud providers. The best path to reduce the risk is diligence in selection, where you pick cloud suppliers that can deliver secure solutions. In contract negotiations, where you establish commitments, options, and incentives that motivate the cloud supplier to deliver security. And finally, in governance, where through monitoring and follow-up, you assure that the cloud solution that you expected from the secure cloud supplier you desired is what is being delivered. And with that, you can have security and data privacy in the cloud. With that, I'd like to turn it back to Linda if we have more time for questions.
Thanks, Brad. Yeah, I think we have a few minutes for questions. And again, for those of you who are on our WebEx, you can submit questions electronically via the Q&A panel in WebEx. If we don't get to your question during this Q&A period, we'll do our best to get back to you following the program. So, Joe, quickly, there was a quick question about just confirming some of the differences between the data breach notification requirements in the U.S. and those under the new GDPR. Can you just kind of highlight again those for us?
Yeah, good question. It's not necessarily a quick one, but there are some key differences. So first, GDPR's notification requirements apply generally to any personal data, so much broader net than in the U.S. per se, but there's a risk analysis that governs whether notification is necessary, and I'll get into that. In the U.S. notification laws, there's usually a narrow definition of personal data that covers only those items that put an individual at risk for identity theft, like Social Security or credit card numbers. So that's one big difference, is just what's the scope of the personal data that triggers the breach notification. Second, your primary liability risk for a data breach under GDPR is large fines. So there's a range of fines, and we told you the scariest one earlier, but not complying with notification obligations can subject the controller and the processor to fines of 10 million euros or 2% of worldwide turnover, whichever is higher. So that's not as scary as the 4% worldwide turnover, but 2% is nonetheless terrifying. Your liability risk, conversely, in the U.S. for a data breach is usually due to class actions, FTC enforcement actions, AG enforcement actions, et cetera. So, you know, the big headline right now is about the Equifax breach, and that so far has resulted in 50-plus class action lawsuits, investigations by state AGs and the FTC. You have claims from financial institutions, shareholders, and small business owners. There's a criminal investigation by the DOJ into insider trading, and there's also a CFPB investigation. So the EU penalties are headline grabbing and bracing, but obviously in the U.S. things come at you from many more directions. And then lastly, the notification obligations themselves vary a lot between the EU and the U.S. So under GDPR, there are three standards basically. First, controllers have to notify a supervisory authority of a data breach without undue delay and not later than 72 hours after becoming aware of the breach, unless the breach is unlikely to result in a risk to the data subject. The second part of the GDPR notification is controllers have to notify affected individuals of the data breach without undue delay if the breach is likely to result in a high risk to the data subject. So this is the risk analysis I mentioned earlier. And then the third notification obligation or GDPR is that processors have to notify the data controller without undue delay after becoming aware of a data breach, and there's no risk analysis involved there. They just must notify. In the U.S., it's not as simple as the three-prong risk analysis approach. Like we mentioned earlier, there's 48 state notification laws to navigate, and there's not much uniformity there. So the data controllers usually have to notify a variety of entities depending on the state. So you might be notifying state attorney generals, affected individuals, credit reporting agencies, law enforcement agencies, and maybe even some other entities. And the notification timeframes range wildly. So some states will say you must notify within the most expedient time possible and without unreasonable delay. Some, like Georgia, have the 24-hour limit that Linda mentioned. You know, there's the 30 days or later standard some places, and then there are other even more vague time frames. The time frames for processor notifications to controllers can range widely, you know, from immediately to without unreasonable delay to the 24-hour standard. And actually, I think I may have misspoke. The 24-hour standard for Georgia, I think that's processor to controller, and then there are other vague time frames. So there's a lot to navigate in the U.S. and not a lot of uniformity right now.
Well, great. Thank you, Joe. We're getting a little short. Just quickly, there's a question about subcontracting. How do you get the ability to approve subcontractors from a cloud provider? And so another good question. You have to think about, first of all, when you go into the contract, you'll find out who the subcontractors are today. So those existing subcontractors could be added to a schedule to the agreement, and you can approve them day one. Then obviously over time, the cloud provider is going to want the flexibility to add or change, delete subcontractors. So, typically what we try to do is do our best to get the cloud provider to notify us in advance of those changes, or, it may be that we can go to a website to check, update, who the current subcontractors are. And while in this one-to-many model, you're not going to get a cloud provider that's going to say, okay, any one customer can veto my right to add another subcontractor, you may be able to do things like, have a termination right, or, change your solution and without, paying a penalty or receiving a reimbursement or pro rata reimbursement of costs, prepaid, because there's now a subcontractor who you didn't know about and no longer approve. And sometimes the provider will say, well, you can't just be arbitrarily not, be unhappy with the subcontractor. It has to be based upon your concerns that they will put you out of compliance with data privacy laws. So those kinds of things can be worked through. So I want to be respectful of everyone's time. We're near the end of the hour. Quickly, thank you again for joining us. Be on the lookout for future technology transactions webinars. Again, I want to highlight the GDPR webinar coming on December 6th. And finally, feel free to submit topics for future programs at techtransactions@mayorbrown.com. Thank you again, and I'll turn it over to the operator for closing formalities.